So the case I want to talk about today is Citizens United versus Federal Election Commission. It's docket number 08205. This is a case from that originated back in 2008 and only was ruled on in 2010. During the 2008 election, a conservative nonprofit organization named Citizens United produced Hillary, the movie. It was a documentary critical of then Senator Hillary Clinton. Because of the political nature of the movie and the fact that Citizens United intended to purchase airtime on video on demand service on cable television, the movie was deemed as an electioneering communication by the Federal Election Commission, the FEC, and was therefore subject to rules governing the production of political ads, including limitations on who may fund them. Citizens United sued in a federal court to overturn the decision, lost, and ultimately appealed to the Supreme Court. So to take a step back, in 1974, Congress passed the Federal Elections Campaign Act to place legal limits on contributions and create the Federal Election Commission, which regulates all federal elections. So when this case was brought to the Supreme Court held two hearings on the case, and its ruling ultimately went far beyond what the plaintiffs had even sought. When the court handed down its ruling, it was to the surprise of many. It ruled that the Bipartisan Campaign Reform Act violated the First Amendment right to free speech. Essentially, the ruling opened the floodgates of unlimited donations, allowing for commercials to air without the approval of candidates, although the court did also mandate that the candidate and the PAC could not work in conjunction with each other, but it further making it challenging to, that kind of further makes it more challenging to rein in the non-factual campaign aids, because even when a non-factual is aired, those who are campaigning cannot comment on it. So we all know where this judicial activism started, though. And it started from a very long time ago. In 1866, the Supreme Court offered an opinion in Santa Clara County versus Pacific Railroad Company, where Chief Justice Morrison Waite said in his opening statement, quote, "The court does not wish to hear an argument on the question whether the provision of the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, these apply to corporations. We are all of the opinion that it does." This essentially gave corporations personhood, allowing corporations to have some of the very same individual rights that you and I share as citizens when it comes to exercising their constitutional rights. And that can be everything from voting and taxes and being able to make contributions to PACs. The 5-4 decision permits corporations and unions and other special interests to spend as much money as they'd like to advocate on election or defeat of political candidates by any means they would like, truthful, untruthful, and there's nothing that the candidates can do about it, because they would be breaking federal law if they engaged with the political PACs. Laws that bar those interests from contributing directly to candidates remain in place. So whereas you can contribute as much money as you want to a super PAC, you are also limited in how much you can as an individual to an individual candidate. So essentially the courts gave these super PACs or corporations that are also tax exempt this large amount of room that is far greater than the individual right guaranteed by the Constitution. That's what a lot of people see Citizens United versus Federal Election Commission. The majority agreed that by limiting the money contributed by many, it would effectively be contrary to the First Amendment rights as citizens of free speech. Now that may be correct, but those who dissented found the ruling as the greatest harm to this nation's political process. And I would agree with that sentiment. I believe that Citizens United versus Federal Election Commission was a horrible ruling, was a super judicial activism example, and it needs to be overturned.